All rise.
About that.
Mask.
You think you get the hang of it after a year? Still don't. Yes, Ms. Phipps, thank you very much. Now we were moving on to the. You want us to turn up the judgment?
Yes, I'm going to look at the instant case now.
Yes.
The ratio of Mrs Justice Judd's decision can be found at paragraphs 29 and 30 of her judgment at page 81 of the bundle. My learner friend has already taken you to this. So she concluded at paragraph 29 that there was force in the point that I made about the issue to the husband's debt. As would be expected, there were no orders to costs in the Children Act proceedings, which required a fact-finding as well as a welfare hearing. Likewise, as has been submitted, there were no proper grounds upon which a cost order could have been made at the end of the financial remedy proceedings. While the judge acknowledged that it would be wrong to say that the costs of the criminal and some of the children proceedings should not be his, i.e. the husband's responsibility from his own resources, the order he made in fact allowed the husband to recover very much the lion's share of his costs from all the proceedings. And I note that the husband chose to pay his legal costs when he could have obtained public funding in the criminal proceedings. The judge did not really explain why this was, or to set the payment of such a sum in the context of the wife having to pay her own very substantial cost bills, and particularly where the deputy district judge had found that the husband had been violent to her by assaulting her on 2 occasions. And she said at paragraph 30, she accepted my submission that by making the order he did, the judge in fact put the wife in a worse position than if he had simply made a cost order against her. So that was the ratio behind the decision that the husband should bear responsibility for his own costs, and I'm urging the court to uphold that part of her decision.
Can I be very unfair and say what is the key point in that reasoning?
The key point is this: we say the discretion miscarried because the judge did not set out his reasons why he was making the order he did. So the sentence.
So it's a reasons appeal.
It's a reasons appeal, really. The most important sentence is at the bottom of paragraph 29. The judge did not really explain why this was, or to set the payment of such a sum. I've already read it to you, but that's the key in my submission. And then secondarily, the submission, the point that in making the order he did, the wife was left in a worse position than she would have been in had a cost order been made against him. Forgive me. So we say, as I say, that the discretion miscarried because of a lack of reasons, and I'm going to come to look at that in more detail in a moment. Can I just say as a preliminary observation that in my submission, the husband, through his counsel, is trying to import into His Honour Judge Robinson's judgment conclusions and findings which are not apparent from the face of the document. And in my submission, the court needs to consider the actual words of His Honour Judge Robinson's judgment, not what the husband considers it should have said. This is a small point and nothing's going to turn on it, but we don't accept that the court at first instance found that the husband was the primary carer for the party's son.
Well, I think she quickly corrected that.
Significant,
yeah.
Yes. But just a small point in relation to that. I've already said that as a preliminary observation, I accept that the judge's decision was a discretionary one, but I say the discretion miscarried because he failed to give sufficient reasons for his decision. Also, I would add to that his decision was wrong as a matter of principle because he made an order against the wife that was tantamount to a costs order. So in terms of His Honour Judge Robinson's judgment could I invite my lady, your lordships, to turn to page 102 of the bundle, which is where we find the judgment. And in particular, if I may, I'd like to draw the court's attention firstly to paragraph 4. The judge deals with the background. Line 4, he says, the case has been marked by extreme positions and a degree of bitterness. And then he goes on to discuss the amount of paperwork that he had to deal with in the course of the final hearing. And I would emphasise that that was extreme positions and a degree of bitterness on both sides. At paragraph 5, he set out the husband's and indeed the wife's costs. I understand from my learned friend's earlier submissions, obviously I wasn't representing the wife at this hearing, that was the learned judge specifically asked for a breakdown of the costs. He sets out that the husband's costs of financial remedy proceedings were £177,000, including interest on his litigation loan, and including the £8,000 which he'd received from a previous order, and about £118,000 for the wife. That didn't include the cost of the children proceedings. The husband's costs for those were £48,864, wife £34,000, costs about £13,000, and both parties had borrowed heavily from their families to cover the costs. So in total, the husband's aggregate for all sets of proceedings of costs were £238,864, and the wife's were £152,000. Paragraph 12 on page 105, he deals with the parties and their evidence. In fact, in paragraph 11, he reads into the judgment the findings of Deputy District Judge Orchover in the Children Act proceedings. And then at paragraph 12, he says that he found the mother to be convinced of her own position so as to refuse to give any credit to the husband and to have difficulty telling the difference between exaggeration and denial. She feels she was the only contributor to the marriage and that as a result he should have nothing. She would not hear any argument that contradicted this. The husband was also prepared to exaggerate freely and made grandiose claims that he could not substantiate. He knows how to wind up the wife and at times appeared mischievous. None of this has much bearing on my findings, save that I do not accept the account of either without needing to check for exaggeration and excessive emotion. Again, both parties were criticised by the judge for the way in which they presented their evidence. Paragraph 17, the judge dealt with the loan from the husband's sister. He accepted her evidence. Didn't know why she needed to be called, there's very little challenge. And the current indebtedness to her was £122,560.47, mostly for legal costs as well as some living expenses. She expects to get that back from the lump sum he secures. And then at paragraph 20, he deals with the asset base, which you I won't repeat that because we looked at that earlier with Mrs. Owens. Paragraph 29, again, criticism of both parties, page 107. I cannot understand how this can be said. Sorry, I'd better start from the beginning of the paragraph. These parties have been living together as husband and wife for 11 years. I cannot understand how this can be said not to provide him with an entitlement to have his needs considered, and I rhetorically ask on a gender-neutral basis what would be the case if the roles were reversed. The property particulars on either side are unrealistic and unhelpful. It is a waste of time for properties to be on the one hand unrealistically high and on the other unrealistically low. This may be a common problem, but it's particularly noticeable in this case. Again, both parties criticised at 108, paragraph 30. On the one hand, the husband's particulars are very much designed to be of the same value and in better locations than the wife's, and the judge decided to look at the internet in the end to arrive at his figure of 400,000 for the husband. As far as the debts are concerned, and this is obviously the issue on these cross appeals, these are dealt with in paragraphs 31 and 32 of the judgment. So the judge decides to award the husband 425,000 for his housing, purchase costs and car. And he says this: I recognise Miss Owen's argument that if I do not provide for that, i.e. his debts, I am not dealing with his needs. Although his costs of these proceedings are greater than hers, there is some reason for that, and I am not going to deal with that in a mathematical way. But I do think it would be wrong to say that the costs of the criminal proceedings, and perhaps some of the costs of the children proceedings, should not be his responsibility from his own resources. I will award him a sum of 200,000 towards his costs, which will go a long way to dealing with them. Will certainly allow him to pay off his litigation loan and will allow him to go a long way to pay off his sister. What we say about those paragraphs is that, firstly, the only explanation the judge gave for ordering the sum of 200,000 was, although his costs of the proceedings are greater than hers, there is some reason for that, and I'm not going to deal with that in a mathematical way. Clearly, there is a lack of reasons in that sentence. There is no explanation for what the some reason is, and the phrase, I'm not going to deal with that in a mathematical way, it is difficult to discern what the judge meant by that. The other point I'd like to emphasise is that Moylan friend argues that the judge did not include much, if anything, of the cost of the children proceedings within his assessment of the figure of £200,000. But in my submission, the strict reading of paragraph 32 is that he did, because he says specifically, I do think it would be wrong to say the cost of the criminal proceedings, and perhaps some of the cost of the children proceedings should not be his responsibility.
Well, don't we just do the sums?
Yes.
So what figure was in the figure of 200,000 that would be attributed to the children's proceedings?
Well, the judge didn't break down the figure of 200,000.
But we can do it.
Yes.
I mean, if you're saying he went wrong because it was inconsistent. On the one hand, he was saying he wasn't going to put the children proceedings, and then he said perhaps some of the cost. Let's tell me what the figure is.
It's difficult to know from the judgment because he specifically says I'm not going to deal with it in a mathematical way.
Why is it difficult? We know that there's 200,000. We go back to where you told us the figures are.
It's paragraph 5, I think.
We go back to paragraph 5.
So there's 177 for
I haven't brought my calculator in, I'm afraid.
There's 177 for the litigation loan, but my client had already paid 8,000 towards those costs. So the 177 includes the 8,000 that my client had already been ordered to pay in relation to the abortive intervention.
And she'd paid that, had she?
And she'd paid that.
All right.
So that takes that figure down to 169. 169, forgive me. And then the balance, we would say, would be the children costs. So that would be £31,000. My friend, in her skeleton argument, argues that that is not, in fact, the mathematical calculation, but of course, one doesn't know from the judgment, other than the judge specifically said, I'm going to award 200,000 towards the the husband's costs. So, Mrs Justice Judd, in the paragraph that I've already taken the court to, was right in my submission to hold that the judge did not really explain why this was, or to set the payment of such a sum in the context of the wife having to pay her own very substantial cost bills. That was a judgment she was clearly entitled to make based on the deficiencies in my submission in his Robinson's judgment. I'll turn now, if I may, to the husband's grounds of appeal, which are on page 16 of the bundle. I have probably covered some of my points within my submissions already, but I'll just ensure that I am not dropping any balls. The first point is that the judge was wrong to overturn the judge's decision because HHJ Robinson had an almost unbounded discretion. I have accepted that, of course, a judge in a financial remedy case has a discretion to award a lump sum in relation to costs. I part from my learned friend's analysis to this extent. The comment by Mr Justice Mostyn in FF and KF in fact refers to, on close analysis of the text, accommodation and sustenance rather than lump sums towards costs, which is the specific issue on this appeal. But probably nothing much turns on that, whether it's a discretion or an unbounded discretion. But the exercise of the discretion must be fair, made on a principled basis, and, importantly, the judge must give reasons why he exercised his discretion in the way that he did. The only discussion as to why the judge ordered my client to pay $200,000 towards the husband's costs is at the end of paragraph 31, the sentence to which I've already taken the court. Forgive me. In addition to the sentence I've already taken the court to, there's paragraph 31. In fairness, in fairness to the judge, I should take the court to this. Page 108 of the bundle. My learned friend relies on this. Paragraph 31. Halfway down, I recognise Miss Owens' argument that if I do not provide for that, I'm not dealing with his needs. Although his costs of these proceedings are greater than hers, there is some reason for that, and I'm not going to deal with that in a mathematical way. Forgive me, I've already taken you to that. And I've already made the point that he did not explain what he meant by there is some reason for that, and I'm not going to deal with that in a mathematical way. In my submission, if one reads the judgment of His Honour Judge Robinson, he did not make any findings that the wife was guilty of litigation conduct. And if he had considered there was force in the arguments in relation to this, it was incumbent upon him to set this out explicitly, which he did not. In my respectful submission, it is simply not good enough to simply say there is some reason for that, without, if by that he meant, as my learned friend is suggesting, that my client was in some way guilty of litigation misconduct, then that needed to have been spelled out explicitly.
It could be short of litigation misconduct, couldn't it? It could have been that even if it was felt, and I don't know whether it was, that the excess costs that were run up dealing with interveners and so on, and the time lost which led to interest on the litigation loan, doesn't have to be litigation misconduct, does it, for it to have been reasonable for his cost to have been more than the wife's?
No, I accept that, but my
he should have said so.
He should have said so. Yeah. Can I just turn my back? I've already taken you to the parts in the judgments which make the point that both parties had adopted unrealistic positions in this litigation, not just the wife. Both parties have put forward unrealistic property particulars. And the judge did not explore in any way the reason the husband's costs were so high and so much higher than the wife's. Part of the wife's case, for example, and I made this point to Mrs Justice Judd, is that the husband had instructed Queen's Counsel for some of the Children Act hearings, and that he'd had a lead solicitor and a junior solicitor at court on occasion. Was this reasonable? Why should the wife have to pay for this? None of that was considered. The judge also failed to take into account that the wife had already been subject to two costs orders, one of £3,000, which was the wasted costs of the FDR, and one of £8,000 in relation to the abortive intervention. And in my submission, she cannot be punished twice for those events. And we've already touched on this, but in my submission, he did not make it clear how he'd arrived at the figure of 200,000. as I've already identified, all we know is that he assessed the husband's financial remedy costs at £177,000, inclusive of litigation, loan, interest, and perhaps some of the cost of the children proceedings should also be added to that. And in my submission, he did not give reasons as to why the wife should, in effect, be subject to a cost order in the husband's favour, so that she met not only her costs of this litigation, but also his. In my submissions this morning, I've already made the submission that the submission made on behalf of the husband that it is conventional for judges to award payments for debts referable to costs in needs cases goes too far. It is within, of course, the court's discretion, but to elevate that to a convention in my submission is to, as I say, go too far. And that submission was decisively rejected by both Francis J. and Cohen J. It's asserted in ground, if I can turn back to page 16, which is the notice of appeal, grounds of appeal. It's asserted in 1B that the appellant's conduct of the litigation was not criticised. Well, both parties' conduct of the litigation was criticised. The level of the appellant's cost was not criticised. It was not subject to any rigorous examination at all. The respondent's litigation conduct resulted in increased costs. In my submission, that's not a point one can draw from the judgment of His Honour Judge Robinson. That was a submission that was made. But if that were his finding, then he would have had to have made that explicit. The appellant needed to clear his debts, at least in part, to be able to meet his housing needs at the level assessed as appropriate for him by HHJ Robinson. In relation to that, I've already made the point that needs are not sacrosanct, and in relation to Justice Judd's decision, of course, she specifically said that she considered that the charge was appropriate so that the husband could meet his housing needs at the level as found by the judge. And I appreciate that my client is seeking to appeal that part of her decision. But certainly, if the court were minded to leave the charge in place, the husband can still purchase at £400,000, albeit subject to the charge. So in paragraph 48 of Moylan and Friends' skeleton argument, she sets out, I don't need necessarily for the court to turn to it, but she sets out a list of submissions in relation to my client's alleged litigation conduct. But none of these arguments found their way into the judgment. It's not possible to discern whether the judge found the litigation conduct alleged proved or not. In my submission, both parties were responsible for the fact this case ended up at trial. Both parties adopted what the judge found were unrealistic positions, and yet it was my client who was ordered to pay not only her own costs, but most of all of the husband's financial remedy costs and a significant proportion of his Children Act costs as well, with no proper reasoning given as to the fairness of that decision. In fact, Mrs Justice Judd accepted the submission that there were no proper grounds upon which a cost order could have been made at the end of the financial remedy proceedings, based upon the judgment of His Honour Judge Robinson. In terms of ground 1C, it's asserted that the effect of Mrs Justice Judd's decision is to undermine the core purpose of His Honour Judge Robinson's award. I think I've already dealt with that. Needs awards cannot be regarded as sacrosanct, and in any event, on her decision could still purchase at £400,000, subject to a charge in favour of my client. In ground 1C2, it is said that her decision provides the basis for the establishment of the principle that it's wrong to award outright a lump sum towards debts where those are referable in whole or in part to costs, even when the considerations set out in subparagraph B above apply. Well, I've already dealt with the fact that we do not accept the considerations as set out in subparagraph B, but in any event, Mrs Justice Judd's decision does not establish a principle that it is wrong for a lump sum to be paid towards costs. In this particular case, on the facts as set out in His Honour Judge Robinson's judgment, she found it would be unfair to make my client pay an outright lump sum of $200,000, that the husband should be responsible for his own costs, but that in order to maintain his housing, that would be secured by way of a charge. That does not, in my submission, establish a principle as is set out there. Round 2 is a complaint about the impact of the charge on the husband.
Apart from A, you'd probably agree with all of that, wouldn't you?
Well,
because you yourself think so.
Well, my client also is concerned about the fact that it's antithetical to a clean break. What I don't accept, where I part company with Mrs Owens, is that the fact there is acrimony between the parties or that they don't particularly get on is not a reason not to impose a charge. So in S&B,
well, your point about the clean break, I mean, of course it's inconsistent with the clean break.
Yes.
But whilst courts aren't wild about them, as long as the court considers that it bears in mind that it's not consistent with a clean break, you're not saying a charge should never be made because it's not consistent with the
no, I couldn't possibly make that submission.
No. So you're reminding the court, are you, to have...
Yeah, well, in essence, the main complaint about the charge from my client's perspective is
that she doesn't want him to have anything.
Well, that's perhaps one reason. But the main reason is because it is only triggered by either his remarriage or cohabitation or his death, the likelihood is that she won't ever recoup the money during her, or she possibly not during her lifetime, certainly not, hopefully, for many, many years. So it doesn't really address her concerns about raising the money and paying it. And it does leave these parties tied together for potentially the rest of their lives. Had she been minded, the judge, to include as a trigger event the son turning 18, then it might have been more palatable because, of course, there was then a shorter period of time during which the parties would be tied together in this way. And, of course, one of the reasons the court imposed the charge in the first place was out of concern of the husband needing to provide accommodation for his son. What I do say about the ground 2, though, is simply that, as my lady, I would respectfully agree, if the court considers that a charge is appropriate, even though it's antithetical to the clean break, and even though the parties may be a very acrimonious situation, then the charge will be imposed. The fact that neither party particularly is keen on that outcome wouldn't prevent a court, I'd have to accept, from imposing that solution.
Well, it's the age-old thing, isn't it? Sometimes the correct, I'm not saying it is in this case, but sometimes the correct result is the one that neither's very happy with.
Well, on that point, you asked me earlier about the positions the party adopted before Mrs Justice Judd. And I reminded myself that, of course, I didn't prepare the original skeleton argument. That was done by my predecessor. I simply argued the appeal orally with a short supplemental skeleton. It wasn't something that was addressed during the hearing, but Mrs Justice Judd, if we go to her judgment, did in her supplement, because I subsequent to the judgment, wrote and asked for further reasons. And she deals with it at page 82 in paragraph 3, where she said the gulf between the parties' open positions at the appeal hearing was very substantial. The wife arguing the husband should be awarded nothing, and the husband that the order of His Honour Judge Robinson should be upheld. It was highly likely the court would come to a decision that was not advocated by either party. The order of Cohen J, dated the 5th of November, particularly drew the parties' attention to the possibility of some of the husband's costs being a charge. I considered the case entirely afresh, but the provision of a charge was, in all circumstances, the clearest solution. So,
was that correct in law?
Considering the case afresh. Perhaps unfortunate that she used that word, but what I think she meant was that she was not bound by the way in which the case was advocated by the parties.
Nor perhaps by what Mr Justice Kern said when granting permission.
Yes, of course.
You might be
yes.
referring to that.
Might be.
We know from her judgment itself that she did consider where she took the view His Honour Judge Robinson had gone wrong. And of course, I'd remind the court of what Mr Justice Wilson, as he then was, said in essence. So I am thrown back upon a charge for which I share the judge's lack of enthusiasm. Nevertheless, to say of a litigant, since she cannot pay him now, she should never pay him, is to stand justice on its head. Ground 4 is, forgive me, hopping around the bundle, page 16 again, is a point about the proportion of the assets that the husband received. In my submission, that is not a that argument must fail, because the issue of the proportion of the husband's awards against the overall assets is irrelevant when it comes to considering a needs-based claim within the context of a case where there's no sharing claim. We know, for example, from MB and EB that the wife was worth more than £50 million. I haven't calculated what the husband in that case received as a fract, but it would have been
But there was a
tiny...
prenup in that case.
There was, I accept that. Equally in K&L, I think the husband in that case received 9%. But it was the proportion point doesn't take the case any further. Ground 5. Well, this is the point my learned friend complains about, the references to the findings of domestic violence. In my respectful submission, and this was discussed earlier in Mrs Owens's submissions, that was not the ratio of Mrs Justice Judd's decision.
But it would be wrong, wouldn't
it? Within the context of the Children Act proceedings, there is a respectable argument in my submission that the husband shouldn't have recovered any of his costs, in particular in circumstances where there had to be a fact-finding hearing because of allegations of domestic violence, which were later found to be proved. But it wouldn't go to the assessment of his costs within the financial remedy proceedings. But that's not what, in my submission, the judgment says. It was reasonable for her to refer to this in the context of the husband's Children Act costs, as I've already said. It simply added weight to the submission that the wife should not bear any responsibility for the husband's costs of those proceedings. Round 6. I have addressed the court on this. I don't accept that Mrs Justice Judd did make a mistake about this if one considers the words of the judgment of His Honour Judge Robinson on its face. And I've already taken, Your Ladyship, my lords, to paragraphs 31 and 32. He made it clear that the £200,000 was towards the husband's costs. and I've already made the point that clearly included some of the costs of the Children Act proceedings. Ground 7.
I don't think you need to address this on that.
Thank you. In relation to the wife's appeal, I've probably already dealt within the submissions I've made so far in relation to the husband's appeal. We are inviting the court to uphold Mrs Justice Judd's decision that the husband should bear responsibility for his own costs for all the reasons that she said. The difficulty where she was wrong, we say, is requiring my client to loan him the money, possibly for the rest of her life, unless the husband remarries or cohabits. In her judgment, page 83 of the bundle, where she's giving further reasons, at paragraph 4, she says about 4 lines up from the bottom of the paragraph, if the husband cohabits or marries someone with little or no financial means, it would not render him homeless, although he might have to seek a cheaper property. My judgment is that the unfairness to him of that is less than the unfairness to the wife that he should marry or cohabit with someone of means and she cannot realise the charge. I'd simply make this point, that if Mrs Justice Judd took the view that it was possible for the husband to purchase a cheaper property if he were to remarry, then it's somewhat illogical for her to find that he cannot purchase a cheaper property now. And this brings me back to the point about needs not being sacrosanct. So the figure of 400,000, which was attributed to the husband's housing need, is the first brick in his decision as to how he was going to exercise his discretion. But when considering costs, that figure should not have been regarded in my submission as being set in stone. And if the judge considered that the husband should meet a proportion or all of his costs from his own resources, then that was the inevitable consequence of the case being litigated in the way it was. As I say, I have to accept that both parties' approach was criticised by the judge. So the figure of 400,000 was not set in stone, and there was evidence. I accept the judge found that it was not ideal, but there was evidence before the court that the husband could rehouse for less than 400,000.
Well, it wasn't accepted by either judge, so how can you now submit to me that we should?
This is in the point. This is in relation to the point about the appeal point about the husband not receiving.
So we should say, actually, be fine to have the amount that both the judges said was not appropriate.
Well, what I'm saying is that it was wrong of both judges not to take account of the fact that what they were ordering my client to pay was effectively a costs order.
Well, I have that point.
And that if that meant that the husband couldn't rehouse at the 400,000 that it was ideally found that he should have, then that was a problem for the husband.
I see, thank you.
Is paragraph 4 the only place where the judge mentions, this is obviously Mr Justice Judd, mentions what would happen in the event of the charge being realised?
Yes.
Namely, that the husband might have to seek a cheaper property.
That's the only place where she makes that particular point.
And she had property particulars before her.
What happened was, as you may have seen from Mr Justice Cohen's order, both parties were required for the appeal to put forward property particulars in a range from the figure that the wife was advocating at trial of 240,000 up to the figure that was ordered. The wife did that. The husband, just before the appeal, put some property particulars in, but they were all at the higher end. I reminded myself over the lunchtime adjournment of the least expensive property that my client had put in, and it was £268,000, which was a 2-bedroom flat with a garden. That evidence was before Mrs Justice Judd as a consequence of the order of Mr Justice Cohen.
So the range was 270 to 400?
Yes. Unless I can assist you any further, those are my submissions.
Anything else? No, thank you very much. That was very clear. Anything in reply?
Very, very little, my lady, my lords. The point which my learned friend brought up just before lunchtime, which is that she's now asking for a new trigger, that being TM becoming the age of 18. Well, it's not a ground of her appeal that the charge was wrong, because it didn't include that trigger. And if I could ask you to look at paragraph 34, page 82 of Mrs Justice Judd's order, a judgment, I beg your pardon, you will see the last 3 lines. The charge may be transferred to a subsequent purchased property if the husband chooses to move. Given the husband's age, I do not think it is realistic for the charge to be realised when the party's child reaches 18. Now, obviously I wasn't there, my learned friend has the advantage there, but even if it wasn't because of something my learned friend said, it was considered by her. And then what the court does know, because she was asked to give further reasons, is it's not dealt with in her further reasons in the manner you would expect it to be. Had my learned friend said, can you give us some more reasons as to why the charge isn't to be realised when TM is 18? If that's not enough, when TM is 18, my client will be 69. And what my learned friend now, at the 11th hour, on behalf of her client, asked the court to order, is that at the age of 69, he should be forced to use his remaining capital, which nobody has said is enough to buy a property with, to presumably rent. And then the last point on this, my learned friend says, well, of course, the house was given to him so that he could see his son, and to paragraph 27, or I'm assuming this is what she means. So this is page 107 of His Honour Judge Robinson's judgment. Under conclusions, I consider all the section 25 criteria. Interest of the child, TM's not present staying with his father, only supervised contact, but he hopes at some point in the future that he might be able to, and I consider that is a reasonable aspiration, whatever happens in the Children Act proceedings. But then he goes on to say, paragraph 28, what I do not accept, he must have a house of the same size and value of her house subject to a mortgage, potentially a mortgage free. I look particularly at the party's needs, need to balance those. I do think that it is reasonable and realistic for the husband to seek a home of his own. And I think that given the length of this marriage and the history of it, it's unrealistic to suggest it should be treated as a short marriage to which he should have out what he put in. So that is not related to TM. And then at paragraph 29, these parties have been living together as husband and wife for 11 years. I cannot understand how this can be said not to provide him with an entitlement to have his needs considered. And then he rhetorically asked the gender neutral basis what would be the case if the gender roles were. But his entitlement to have his needs considered was that both judges said that he should have a small property with a garden. This isn't a Schedule 1 case where it goes back at the end of the child's majority. In relation to, moving on, in relation to MB and EB, the facts of that case were not that the husband just had a flat. The husband had a flat and a studio as well. And he was living in the studio on like a raised platform. And what Mr Justice Cohen effectively said was because he was renting out the flat to give him an income. So Mr Justice Cohen said he needs both. He shouldn't be, living in his studio. He needs both. So, of course, the husband in that case was saying, I want another flat to fulfil those needs. And he said, no, you need one or the other. You need to live in your flat and have an income, or have a flat. And what he did was gave him an income. But it wasn't as simple as, he didn't have a property, or he only had the one property. There were two properties, one of which he had been living in for some time. In relation to the costs point, the 257 versus 200 versus 238, in my submission, it's much more simple than anybody, certainly than my learned friend thinks. And it's as I said, 257 less about 62 takes you to 197 or something like that. So he rounded it up, and that was it. And he makes it clear that the debt to the sister included living costs. So even if you do say, oh, well, he got 100% of his financial remedies costs, and even if you knock off the 8,000 that was paid for the intervener's costs, there's only £31,000 there, and the sister was owed £122,000. In terms of my learned friend saying, well, you can't really say, there was litigation misconduct, I vehemently disagree with that, because it is a matter of record that there are two cost orders in this case, and they are two different cost orders. So one is in relation to the wasted FDR, and the second one is in relation to the wasted costs of the abortive intervention of 3 interveners.
Well, I do think we have to be proportionate here, because these, in the context of the overall costs that were run up, were very modest costs ordered. And it's very hard to say that we can draw an inference that there would be litigation misconduct by the fact of 2 relatively modest cost orders made during the currency of lengthy proceedings, isn't it?
Well, my lady, no, because, and I would ask that you see the clip of orders in this case, if you feel it would assist you, because the orders do speak for themselves. As to what the wife was doing, it was set out in every okay. But here, perhaps even if you're not with me on that point, what about this point? One of those cost orders is still not paid. Now, how's that for litigation misconduct? She is in breach, a barrister. She remains in breach of a cost order that was due to be paid by the 16th of January 2019. She remains in breach of just a small 3,000 cost order. And of course, she paid the intervener's costs because she was always, we say, she was, it was a sham case, but we'll never know that because it wasn't tried. But that was listed for a 5-day preliminary issue, and that had to be vacated. But there's been no incentive for her to pay her own cost order, even two appeals later. Despite
I think small though the point may be, one of them one of the points being made by Ms Phipps was that the judge was actually awarding 200,000 plus 8 plus 3. I thought that was the point that was being made by Ms Phipps about this cost order. So in other words, the judge gave the husband effectively 213,000. Is that right?
Yes.
211,000.
Yes. Yes. Except 3,000 hasn't been paid. In relation to the cheaper property point, the Mrs Justice Judd saying cheaper property point. There were no cheaper properties, and so, or none that would be available to my client. Even the wife hasn't said this. None that would be available to my client with what he would have left if the court acceded to her position. So at paragraph 29 on page 107, I beg your pardon. You will see right at the bottom of the page, this is where His Honour Judge Robinson sets out the wife's properties. The wife's properties suggested, insofar as she puts them forward at all, which she wasn't, at £240,000. Well, he couldn't afford one of those if he had to pay all of his own costs. And then at paragraph 17, on page 78, again, the last line of that paragraph, Ms Phipps took me through a number of the properties produced and pointed out that there are flats available in the area that the husband is currently living which can be purchased for under 300,000. I think Ms Moylan, if everyone correct me if I'm wrong, she said the lowest of those was 268. I'm grateful. So, you know, Mrs Justice Judd's position doesn't hold up because nobody put forward a case that he could purchase a property for what he would be left with if he had to pay. And I think I've already addressed you on the point about my client's age and the charge.
So what you're saying is that it's not just that he'd have to cut his cloth, it's simply there would be no house.
There would be no house. There would be no house. And then what he would have to do at the age of well, depending on when the charge was triggered, if it was triggered come what may, when TM was 18, he'd have to cannibalise his capital to rent until it ran out.
Whereas remarriage or cohabitation are lifestyle choices.
Remarriage, yes,
TM
yes.
Achieving 18 happens regardless.
Regardless, God willing, yes. So I think that is those are my replies, my lady and my lords. Unless I can be of any further assistance, and perhaps just whether or not you want to see just the orders in this case. I do say they speak for themselves, and they are a matter of court record.
I don't think so. Thank you.
Unless I can assist. Your lady.
The general principle is no orders to costs. And the consequence of that is that each party will obviously be responsible for meeting their own costs. In paragraph 30 of her judgment, Mrs Justice Judd accepts a submission made to her that the judge should have balanced the decision he had come to as to the husband's reasonable needs for a property as against his responsibility for meeting his own costs for the litigation in which he had become involved. Have you got that?
Yes,
Paragraph
I have
30.
it. Yes, I have it.
What submission do you make about that? Do you say that Mrs Justice Judd was right that those two factors have to be balanced?
Well, in my submission, His Honour Judge Robinson did just that.
So your submission is that they do have to be balanced?
Well,
But-
yes,
but-
yes.
but-
Just
right.
like all of the judges in all of the cases we've looked at have done precisely that. So just like Mr Justice Francis did in WG, and just like...
No, it's okay. So your submission is that Mrs Justice Judd was wrong to conclude that His Honour Judge Robinson had not done that?
Yes, my lord, yes. Because he does, you know, it was as he says at paragraph 21, Mr Wilkinson forcefully put the point. And of course, the appellate court shouldn't look at that narrow textual analysis. What you know with some certainty is that His Honour Judge Robinson took it into account because he set it out in paragraph 21. And as I said, Dagger and Banger was quoted to him, and that's of course is one of those cases.
Thank you very much indeed.
My lord.
Well, thank you both very much for your submissions in relation to this case, which is, of course, critically important for the parties involved. But as we noticed when permission was given for this second appeal, raises some important issues for us to consider in a wider context. So it won't come as any surprise to hear that we're going to reserve our judgments. They will be sent out in the normal way in due course for you to consider any typographical, minor grammatical errors or minor errors of fact. It's not an opportunity to re-argue the case, obviously. Not quite sure when that will be. Given the time, I'm sure we'll still be, to this extent, subject to COVID regulations. I anticipate that the judgment will be handed down in the current electronic form rather than attendance at court. If by any happy chance we're back to full open court, then there's no need for any of the parties to attend. So I'd hope that we can deal with all other matters in writing, please, and that when we have handed down our judgments, you can agree an order between you.
Court rise.
Thank you very much.
Just to let you know, we're still recording as I end this, 90 seconds, so